Thank you, Shai, for a fascinating comment. And now the floor is yours.
Can I answer?
Yeah. Please.
Thank you. Okay, Shai, so our meeting in the corridor was an invitation to write with me about it, and now clearly I see I should have done it. But I disagree with one point with you, and it's probably my fault. I actually I didn't think that we should overcome the tragedy. I thought that we should. That's why I chose Oedipus. I thought that a sense of tragedy is missing in the triumphant international law and the transitional justice literature, and it was a call to recognize it. I also, David asked me earlier on whether I am a new apologetic for the generals, and no, it's not that I think. I actually think that this search for the truth is necessary, and it comes out of this sick society with this kind of organized lie. So it's both necessary and tragic, because this is what it leads us to. So I think there is no really happy endings, but I think that if we are more attuned to this tragedy, we could, I think we could allow deeper thinking about what kind of compromises, what kind of judgments, what kind of politics are we looking to. And the second, about the difference between DNA and the oracular truth, it's interesting because in the Herrera case, finally they agreed to this test, and there were several, but no DNA confirmation was coming through. So, and they thought, okay, so that's the end. But no, every day there is a new couple coming with this understanding that maybe they are the children. So it's a game without end, as Gotti was saying. And I think that even with DNA, we don't have this one resolution. So,
Chris, please. Here.
Well, I think actually you may just have answered the question that I wanted to ask, which is about the conclusion of your paper, because I also was struck by the resonance between your paper and Ayelet's, in particular the way in which different kinds of truth are contesting with each other, and the desire to privilege one particular truth and to elevate it. And I thought that the paper was extremely effective in making that point. And then it seemed to me you ended, however, with having relativized truth effectively, you ended with a different kind of absolute. You ended with a rule of law as an equivalence which I found kind of incomprehensible at one level. That the rule of law that had been undermined, destroyed by the generals, and somehow that destruction was equivalent to a second destruction wrought by this determination to find a particular kind of truth, to elevate a truth of discovery. And I found it incomprehensible because these two different violations seem they're not commensurable. They're not, one leads to 30,000 deaths, the other leads to some inconvenience, one might say. So does your final point mean that that observation is ironic? Or do you indeed have an absolute conception of a rule of law such that the two violations are the same?
Thank you, Chris. I don't think they are equivalent, that there is a strong equivalence between murdering and torturing and this. But on the other hand, I don't see it as just an inconvenience. I see it as a threat to a democratic regime, because I see how it is allowing the society to adopt the same kind of thinking, that there is a good out there and we can forget all about what it means to keep the rule of law in order to get to this truth. So I think a lot is at stake here. It's not just inconvenience for the individual. It's what does it mean, democracy? And for me, democracy means that, there should be limitations on power. Whoever is in power, and law is giving us this limitation, and in a sense, there is no acceptance of this in the Argentina context. So that's what's at stake, and that's why I'm so worried about it, not about just saying, oh, it's the same. I'm not interested in this kind of... but I also think, and what drives me, and I think not only in this paper, I think there is a shift that we hardly see about the relation of law to truth. I think that it's very important for the law to function, to think of truth as something outside, as an inspiration, as something we want to find. But the minute truth becomes internalized into law, as if the law can give you the truth, and it is internalized as a human right of the individual, it is destructive to the law, because the law cannot withstand this kind of promise and this kind of. So I'm very much afraid of this internalization of the truth, and I think people don't notice it. You know, because always the law is also about truth. So what's the problem? So my paper is an attempt to show the problem, to show the transformation that truth is going on, and to pose a question about it.
Can I just say that, I mean, it does seem to me that, I mean, law promises certain kinds of truths, legal truths, truths on its own terms, truths as if. It seems to me that the truth that is threatening to law is of a different order. It's a different order of truth. It's a truth, as you say, that comes from outside, but it's coming on a set of terms that are not law's terms. So I think I think you're doing this, but I think that one has to distinguish amongst these different registers of truth.
We'll take all the questions together.
Can we have like 2 or 3 and then...
Two and three, and we have... Yeah. Yes, and then that's the end of it, because... Pardon me?
We can keep going.
A little over till 12? 5 minutes? 11? All right. Okay, so... Please.
So, Andreas Philippopoulos Mihalopoulos from Westminster in London. So, I just want to thank both speakers for 2 papers, indeed, because I have the impression, although I really very much like Shai's paper, it felt to me that there were 2 different papers here. And the way that, I mean, maybe you should have co-authored or indeed write 2 different things. And indeed, what you were reading in terms of what I read was quite different. And the way that you wanted to use, I suppose, Nietzsche, and it was perfectly, I mean, right spot on, I suppose, was quite different to what Leora was doing with the tragedy. And it was really interesting how, for example, the concept of the DNA, and how DNA for you is precisely the moment, it's the different determining moments in some ways. And for you, the DNA is a contextualization. It's all about the temporality of the DNA. It's about the voluntary nature of the DNA. It's about the kind of the question of waiting, as you say, precisely for the results. And for you, the DNA was the absolute moment of clarity. But it's really quite interesting because I was thinking about if the Dionysiac were to be an airport, its abbreviation would be DNA. In the sense that the Dionysiac is precisely about this idea of absolute clarity. It is the clarity that chaos will never leave. It's exactly the moment of standing on the abyss and seeing the chaos that would never go away. Because precisely the point of the DNA is not clarity, it's not the Apollonian, it's exactly the opposite. It's the beginning of chaos. Because things do not fall into their rightful places. Because what the whole thing about DNA, and indeed Tiresias, is about future, it's not about past. And that's where I think it will tie very well with Chris's paper later on about futurity and temporality. The idea of Tiresias as the blind, and it's quite interesting because we all resisted talking about justice until now, and Tiresias being blind, of course, and all the stuff in the blindfold. The Tiresias is precisely this moment of sort of looking into the future, so he's blind to the DNA, but he's looking into the future. He's looking into the way of the chaos. And of course, future is, again, all about contextualization, etc. But what I just wanted to question a little bit about the paper is that I'm very sympathetic about what you're doing. It's absolutely right. I am just wondering about the way that you're reintroducing the context as the truth, as contextual, etc., which is absolutely correct, I think. But I wonder whether you're missing out a point of teleology, because the search for truth is about a search for future, not for past. It is about a certain teleology, politically and legally determined. It is not just an epistemological teleology, it's a teleology whose epistemology is being determined by the political and legal causes of the truth. In the sense that truth is absolutely, the search for truth is absolutely determined already as a teleology, as a future point. So there is a clear line that begins with the quest, as it were, not even the past, the quest, and links to the future of the particular political direction that one takes.
Simon Stern, Toronto. So thanks for a wonderful paper and a wonderful commentary. And this is really just sort of a brief footnote to Chris's observations that I think might help cash it out in one way. If you think about criminal law more generally, and you think about truth and sanctions in criminal law, you might set up a spectrum going from the system by which almost all criminal prosecutions are resolved, namely plea agreements. And in plea agreements, one might say the truth is very nearly irrelevant, right? The prosecution agrees with the defendant about something that the defendant is willing to plead to, something which generates a sufficient penalty that the prosecution is willing to agree to it, right? So everyone agrees on some state of facts and some offense such that, everyone compromises, and the truth of what's specified in the plea agreement is often largely irrelevant to what actually happened. Then you've got a trial, right? That would be the next step up in the spectrum. And in the trial, assuming that the defendant is found guilty, today often there's an opportunity for a victim impact statement at the end, at the sentencing phase. So this would be the voluntary production of the victim's truth, right? Not the compelled production of the victim's truth, obviously. The victim has the opportunity to testify. And finally, as you quite helpfully point out, these truth and reconciliation commissions, where criminal liability often isn't the point. The point is generating some consensus account of what the truth is. And in some ways, you might think of the truth and reconciliation approach as being analogous to what in the U.S. is called a declaratory judgment, a situation in which the plaintiffs are simply trying to get the court to say something, and often the condition of seeking a declaratory judgment is that you mayn't seek some form of liability to be imposed on the other side as a result of it. So it's this would be a legal declaration of the truth, but one which nevertheless exists in this very interesting zero-sum relation to liability. And so it just strikes me that the very first instance, the plea agreement, is in many ways quite consistent with what you say, Chris, about legal truth, right? Everyone, the judge, the lawyers, the defendant, presumably are satisfied with, if not, actually desirous of, whatever truth is produced through the plea agreement. And so what you get, I think, is an interesting sort of spectrum of relations between some notion of truth, some availability of the imposition of liability. And it just strikes me that setting it out in that spectrum might just help ever so slightly to solidify what I think is actually a terrific point, and on the whole one I find very compelling. Sorry, I passed it the wrong way. Sorry.
Yeah.
Sorry.
So very quickly, I want to ask, I want to also return to Chris's first comment, which is the rule of law that you posit as is, as a, it's unquestioned and it just is. And I would add to that also, you talk about basic rights to privacy and dignity, and those are also presented as basic, as a priori, and that kind of, I guess, undermines a little bit the beautiful way that you show the shifts in truth, right? So truth shifts, but all the rest of these kind of stay static, and I'm wondering about that. And I think this is part of a lot of the same question, and it's a methodological point that I want to make or ask, is the way you use comparative. You compare Oedipus, or the story of the play of Oedipus, and you say the text, not the myth, right? And then this other story that you tell about Argentina. What is the nature of comparison, right? In other words, how does the methodology of what you call comparison work for you? I mean, I think the connection it works, but I would like to ask you to be more explicit about how it works. Is Oedipus a way of jumping off, a way of like triggering an idea that you didn't have earlier? Do you see what I'm saying? So what is the nature of this comparison that you are comparing?
Maybe we'll take two more questions, the last questions. Amnon, and then...
I will be very brief. If I thought that the previous discussion raised the question of value and the relation of value to presumption or value to truth, I think that this really thought-provoking exchange between Shai and Leora raised the question of judgment. Because at the end of the day, I think what you're referring to, Leora, and correct me if I'm wrong, is the tragedy of legal judgment per se. I mean, the issue of Oedipus or Chile or Argentina or what have you, I think is just a microcosmos of what it means to legally judge, which is a tragic phenomena or a tragic exercise by definition.
My question, Ravit Reichman Brown. My question builds somewhat on this comment and actually connects back to the comment that Chai had when he said that Greek tragedy has no normative solution. And I don't think that you offer one rightly in your paper. I think what you're arguing for, to my mind, very, very well, is a shift in tone or a shift in tenor, both in our conversation but kind of internally, psychologically, in our understanding of the problem, of the historical and legal problem as it's unfolding. But one thing that Shai's comment gives rise to my mind, is precisely the fact that tragedy is about the realization of a fate, right? Not the recognition of a fate. The recognition is the oracle, right? That some kind of fate is going to unfold. The rest of the tragedy will reveal how that fate is going to come to pass, right? So there's a kind of always already quality to what tragedy is, what's going to happen in a tragedy. What you've also articulated in the paper is the resistance to this fate, right? A resistance that is tonal again in nature, and it's the resistance of a triumphant tone, as you call it, the triumphalism of transitional justice. But I'm still left wondering at the end what you believe the fate to be, right? The fate that the tragedy is realizing.
Okay, wonderful questions. Thank you. I want to begin, and I think it connects some of the things about the teleology or the. We have here transitional justice is based on this move from past to future, And it's interesting how it justifies it in its investigation about the past. The idea is that we cannot move into the future without investigating this past. And I think the question that I pose in my paper is what does it mean, this going back to the past? What kind of past are we looking for in order to build a better future? And what is the connections? Because I think a lot of assumptions are being put there about the relation between and actually one interesting phenomenon that I'm writing a book about something else, about transitional justice, but I'm looking into all these historical commissions that have been established in transitional justice, and interestingly enough, almost none of them has historians in them. It's all lawyers, sociologists, anthropologists, no historians, and I think this is on purpose. They are looking for a non-historical truth on purpose. So I think it's a very interesting a combination here that we have to raise. So this is about Theresias and so forth. Simon, I want to focus on plea agreements because I think it's a wonderful moment, because the context we are looking at is mass atrocities. And these are different from individual criminal trials. So the question was, for me, was first raised in the Eichmann trial, in which Eichmann said, in a way, you know what, I agree, Auschwitz exists. Now, let's move on. I just didn't do it, yes? So we can get rid of all these 100 witnesses because I agree, yeah? And the judge, in response, says, wait a minute, it's our duty to investigate the past, the truth about Auschwitz and about whatever, because it cannot be that we are going to put the whole history of the Holocaust on Eichmann, who said it was, yes? So there is a huge tension there between the trial that, okay, he agrees, so we can move on, and the need to know. Now, it was raised again, time and again, in the ICTY. Can defendants have plea bargains there? And the court understands that there is a tension there, because we are here, we can't just give the defendants this, and they are trying to balance this need to know the past and officially know the past and the right. So I think we cannot just move between ordinary criminal law and this context, which raises the question even more to the point. Now, Ayelet, and I think Chris, the way I treat the rule of law as an absolute or privacy, I think that only through Ayelet I better understood what Chris was saying. I think that transitional justice, in its initial stages, wanted to change our understanding of the rule of law. That's why it was willing to realize that even without punishment, we have a rule of law and so forth. But this understanding has been, in recent years, has been abolished. And a new legalism and the rise of criminal law was put forward. And so I think I have to put it better inside, because there is a fetish of the rule of law in this kind of literature, and I want to ask it, but you're right that in my attempt to move, I didn't do it. Now, this is a huge question. What does this comparison do? First of all, I think that I needed it as a saving, you know, everybody are celebrating it so much. You know, you go to this literature, it's all celebration of the right to truth, and I needed a different text that would give us a more complex understanding of the search for truth that I think somehow disappeared from the way we treat it now. So it's against this ulteriority, against this difference that I work with what we have there. And this was the question that you raised about how does it change our historiography, the move to the arts or to literature. And I think that the tragic is missing in our historiography. So I think this is what I wanted to put forward. And yes, I don't know what to do with the tragedy of judgment. I think there are several kinds of judgments, and I'm trying to move from determinative judgment to reflective judgment that I think is less tragic in the sense that it's less compelling but I don't know if I do it. And Ravit, I'll have to ask you more because I didn't really understand the fate that you. I have to discuss with it what fate I'm looking for. But I think it's not that we are back to square one in this transitional justice, but we are not just in magic moving to a democratic society, and that's it, and we have to realize this.
Thank you so much.